We begin with the Supreme Court's hearing of the application for the review of the judgment sacking the governorship candidate of the APC, which started few hours ago, with Justice Sylvester Nguta presiding over the ruling alongside 6 others. Well, the court has now risen and is expected to deliver judgment later. But let's walk you through what transpired in the court so far. Well, earlier on, Senior Advocate of Nigeria, Afe Babalola, who is the lead counsel to the APC governorship candidate David Lyon, argued that the Apex Court has the power to set aside its earlier judgment. He pointed out that the application is not for a review of the judgment, but to set aside the judgment which he posits is tantamount to a denial of fair hearing. Another senior advocate, Wole Olanipekun, who is also representing the APC, asks the court to set aside its earlier judgment on the grounds that the court had no jurisdiction to have entertained the appeal in the first instance. He explains that the suit was first filed at the Federal High Court as a pre-election matter, of which it was a mistake for the court to have entertained that matter. He also faulted the interpretation of the judgment by INEC, which issued a certificate of return to the PDP candidate. Well, on the other hand, Senior Advocate of Nigeria, Tayo Oyetibo, representing the PDP, argues that the application by APC's David Lyon is an invitation to violate the Constitution. It's also an invitation, according to him, for the courts to sit in judgment over its earlier decision, which must not be allowed. He pressed the courts to summarily dismiss the application. He also argues further that those points were well considered before the Apex Court arrived at its decision, and that the court cannot change the operative part of any judgment delivered by the Apex Court. He went on to cite Section 22 of the Supreme Court Act, which gives the court wild powers to make any order, including the order asking INEC to withdraw the certificate issued to David Lyon. Well, let's tell you some of the people who were there. Mr. Doye Diri, the governor of Bayelsa State, Mr. Adams Ashamale, the chairman of APC, are among those present in the court. So let's now join our correspondent, Kayla Mega, who is standing by at the Supreme Court to bring us up to speed with the latest happenings regarding the Supreme Court judgment, which is asking, the part is asking the court to set aside the Bayelsa governorship judgment. Hello, Kayla. It's been quite a busy day at the Supreme Court. Can you just give us updates, pretty much?
Hi, Coyote. Okay, so yeah, you basically a review of that judgment, and I say they want to set it aside. Now, the argument against that is that, well, if you're asking them to set aside, to review a judgment, was there any fraud in that judgment? Was there any errors that were in the judgment as well? So they're saying if none of these things were cited by the councils, then why are you asking for a review? So that's the argument that Mr. Tayo has against that. And of course, there's another point that was being raised. Apart from the fact that the Supreme Court has been described, of course, by Mr. Tayo, who is the counsel to the People's Democratic Party, as the Supreme Court, and that supremacy, he says, cannot be challenged. He's also talking about the fact that the justices of the Supreme Court are supermen. Those were his words. And that when supermen speak, then the country has to listen. Also talking about the fact that this is actually a bigger problem than we think it is, according to Mr. Tayo. If a review of a Supreme Court judgment is being done, according to him, this could open up the floodgates for lower courts not to obey the instructions of the Supreme Court. Here's how he explains it. So if the Supreme Court judgment is being reviewed, that means that when the Supreme Court gives a judgment on a matter, lower courts will not be able to take take action immediately, because that judgment from the Supreme Court could be pending on a review. So that's the argument. He says it's to open up the floodgate for a lot of anarchy in the system, so to speak. And he says this is not constitutional at all. And those were his words. It is not constitutional, and that the Supreme Court cannot do what Mr. Afe Babalola and what Mr. Olanipekun are asking the Supreme Court to do. Another issue that was raised was about the difference between setting aside a judgment and reviewing the judgment. If you're going to review a judgment, then you're planning to set it aside. It says there's no difference between both of them. So the arguments went on for quite a while. It was a very interesting, busy morning.
All right, Kayla, we seem to be having difficulty getting you, but as you said, the court has risen, and we expect judgment in the coming hours. Well, still on that issue, as the PDP and the APC begin the legal battle to seek reversal of the Supreme Court judgment, or otherwise, of governorship elections to be in their favors, what do we make of this development? Because as we know it, the Supreme Court statutorily is the final point of arbitration and adjudication. So to make sense of it all, Barrister Anthony Lebo of the PDP and Dr. Joshua Lobo, a lawyer from the APC, both join us live from our Abuja studio. Good afternoon, gentlemen. So, Mr. Lebo, are you worried about the precedents that this might set, pretty much? Because a lot of people, legal practitioners especially, are worried that this is putting the judiciary, the Supreme Court, in a very tricky position.
Well, the question is, what cases are going to the Supreme Court for review? I mean, let's not dwell too much on the legalities of things. Looking at the section of the Supreme Court Act that allows you to approach the Supreme Court for review. This must be your priority when you're looking at a case that has gone for review. Does it fall under this category? Is this review subject to the application of the learned Chief Supreme Court Justices review on their own judgment? Don't forget, in the order of precedence, in the order of hierarchy, the Supreme Court is the highest court in the land, and its judgments are deemed to be final on a matter. But however, there are special and peculiar circumstances within which you can approach them for a review. These things fall under the jurisdiction. The court give judgment under the right jurisdiction. Was the judgment given in error, or was there a clerical error? You know, once the court falls or finds that it has erred in these issues, there are settled cases, Adegoke, Vascoka, where these matters were settled, and the courts had said that it will be tantamount to a natural disaster if it does not reverse itself on an issue that can derail democracy or can derail the course of justice in the country. However, I heard one of the lawyers in the current review in the Supreme Court say that the Supreme Court is not a magistrate court. Our politicians must be careful with the way they toss around or approach or try and demean the high standing of the Supreme Court. If a matter within all legality, it clearly shows that this is a matter that should have been resolved at the party level, such as the Bayelsa issue. Look, again, as a lawyer, I'm very careful about what I say. I do not want to go to the substance of a matter that is even currently ongoing in the Supreme Court. But we must insist that our politicians become very careful. Our politicians give the reverence and respect they need to give to our judicial our institutions in general. We cannot just assume that because there's a matter which people feel legitimately, they should approach the Supreme Court for review. I think if you want to even distinguish, there are cases that you can look at and just say, okay, so this was negligence, administrative negligence on the part of the parties, that it ought to even at this point not be approaching the Supreme Court, but introverting into itself.
I understand. Just a moment, Mr. Lebo. Let's bring in Mr. Lobo now and get him to respond. Now, seeing what is happening so far and what will happen in the coming days, because there are other cases for the Supreme Court to review, are you comfortable with some of these, issues at the Supreme Court?
Once the law is tried, once the provision of the law is applied, and even let me draw the attention of the whole nation to Section 285, Sub 12. That 60 days that is enshrined in the Constitution, any of those cases, once it's cut off with the 60 days, the Supreme Court cannot even go outside the mandate, no matter the irregularity or injustice inherent in those judgments. As far back as 2011, Honorable Justice Onoge in CPC vs. INEC said that Section 285 sub-Cs that prescribe the time limit like a rock of Gibraltar. So if any of those cases, especially like the Imo and Zamfara, with due respect, if they fall within those 60 days contemplated by the Constitution, there's nothing the Supreme Court can do. But in this case, I think it's still within the timeline.
So, Dr. Lebo, just Let's take a look at some of the possibilities here today, because we understand now the court has risen and people are anticipating what the judgment will be. So for our viewers, from what you have seen so far, what are the likely possibilities that might come up?
Well, the possibilities out of the Supreme Court is that one, my friend here said that the 60 days had expired, but he forgets that this matter is not an election petition matter. It did not arise from the tribunal. The law is specific that matters that arise from the tribunal, that is when they are time bound. But a matter that was a pre-election matter, a matter that even before they went into the election, the court had ruled. The court had ruled that this man is not fit for this election. Do not field him. But you know, we have appeal systems and people went to appeal. The Supreme Court did not pass any judgment. The Supreme Court simply upheld what Justice Ekwo had finally given in her judgment. So I don't think there's anything to expect, but that the judgment of the Supreme Court given on the 13th will stand. Because it doesn't make sense. You have presented a candidate that is faulty, and by that default has poisoned the candidacy. So you have no candidate in that election.
Let's find out what Mr. Alobo thinks about the possibilities. You've listened to Dr. Halebo. What are the possibilities you're looking out for out of this hearing?
When you say possibility, there are two options, either to override themselves based on the strict position of the Constitution. And like you say, there was a fourth alteration to the Constitution that prescribed the 60-day timeline that I was earlier saying, Section 285, Sub 12, in pre-election matter. That is very germane for us to capture. But the possibility is that Supreme Court must right the wrong, because the joint ticket that the basis of disqualification cannot rob the governor-elect, because Section 181 provides that if the governor is not even available for whatsoever reason, the deputy governor step in. So now that if the deputy governor have any disability, is the governor to nominate another candidate within the contemplation of the Constitution to be sanctioned by the House of Assembly. So the will of the people must be obeyed. It's not an issue of the, look at even as far back as 1999.
Mr. Alobo, I can hear Dr. Halebo chuckling there. I understand this is definitely a big topic. I mean, you can tell by all the attention we're giving to the Supreme Court. We'll follow that to ensure that we'll bring you the latest. But we'd like to thank you so much, gentlemen, for your time. Barrister Anthony Halebo of the PDP and Dr. Joshua Alobo, a lawyer from the APC. Thank you for sharing your thoughts with us.